Today, we will focus on a case study that involves Croft Scully and MV Skulptor Vuchetich. Croft Scully contracted to ship 1,755 cases of soft drinks from Houston in the USA to Kuwait. Baltic Shipping Co. is a company that owns ships from MV Skulptor Vuchetich. Croft Scully decided to use Baltic Shipping Co. They are owner of Skulptor and they employed shippers stevedoring, known as SS, to transport the 20-foot container. In logistic transaction, the most important document in sea shipment is the bill of lading. It's a document of title. This means that the person who has the original bill of lading in hand is the owner of the cargo. It's a carriage contract. It will show where the cargo will move from and move to. It proves the receipt of the goods. It ensures that the exporters receive payment and the importers receive the goods. The 1,755 cases were loaded in a container, closed and sealed, until the ship came in the port. So, between the arrival of the container and the arrival of Skulptor, vessels agents of SS prepared a bill of lading. But a stevedore's employees, when he was loading the cases, he negligently dropped it. So the cans were damaged. 42,120 cans were damaged. Croft Scully sued shippers stevedoring and Baltic. But you can't sue two companies for the same accidents. So who should they sue? Baltic? No, because they would answer that they subcontracted to SS. Therefore, like they subcontracted, SS is responsible. But it is said that they negligently dropped several containers filled with soft drinks. The trial court said that Baltic was not responsible. But in terms of the Himalaya clause, which is in the bill of lading, it is said that there were liability limits. So what is an Himalaya clause? In the transportation contract or bill of lading, it extends the liability limits which benefit the carrier, but on the contrary, other carriers such as stevedores don't benefit of this. Like it is showed in the case study, if a third party like SS company here, if in a transportation transaction, goods being unloaded from the carrier's ship are damaged, what will happen? If there is a Himalaya clause in the contract, the stevedoring company and the carrier will try to protect itself. But another problem came up. Inside the container, it was said that the goods were packaged. Okay, first, what is COGSA? This is a Carriage of Goods by Sea Act. But according to the COGSA, liability for damaged cargo is limited to $500 per package under COGSA. It limits a carrier's liability for damage in connection with the transportation of goods to $500 per package, or in case of goods per customary freight unit, the nature and value of such goods have to be declared by the shipper before the shipment and put in the bill of lading. So Croft Scully appeals from a decision by the district court. So the paragraph 4 of COGSA limited shipper stevedoring liability to $500. So Croft Scully appeals from a decision by the district court limit to $500 its recovery in an incident where the parties said negligence. So the real question now is, what was the package? Unfortunately, in the bill of lading, nothing was mentioned about what was the package. A container or a cardboard cases? Maybe it would have been better to consider the container as a customary freight unit. But what does this mean? It means that the weight or measurement of the quantity of goods in the cargo are the basis used to reward the exporter if they are damaged. Croft and Scully said that the freight charge was $2,200. We don't know how they found this number, but they said that they calculated it on the flat container weight. Shippers Stavering argued to the district court that the container was a COGSA package, and the court agreed. SS is definitely liable. The case is about the limitation that one can put on containers and how many items per containers are to be considered in one package.